So one of the things that can be decided in a medical negligence claim or a public liability claim is any consent that you've given. So if you imagine you've taken your kids to a trampoline park and you've signed a waiver and you've consented to there being some risk, it's a physical activity, there's a lot of running around, jumping around, and there is the chance of risk. So if your child gets injured and you've consented to the possibility of them being injured, doesn't mean you don't have a claim. And the reason is you cannot consent to negligence. So if your child is injured at the trampoline park because a member of the staff have left a tripping hazard on a trampoline when they shouldn't have done, then just because you consented to the injuries, potentially, doesn't mean that you can't claim because it was negligence that caused it. And it's the same with medical negligence. So when you have an operation and you are looking at known risks, as there are with all operations, you sign a consent form that there's a risk of infection or there's a risk of bleeding or whatever it may be, you consent to that risk. But if that occurs due to negligence, so let's say the bleeding started because the surgeon cut a vessel or a vein that he shouldn't have done and it was negligent that he cut it, just because you were bleeding and you consented to bleeding doesn't mean you don't have a claim. So it's always important to read any consent forms before you sign them, but then once you've got your medical records or once your solicitor has, have a look at them, understand them, and look at what actually caused the problem that you're complaining about, rather than just looking at the problem as a whole. If you're unsure or you've got any questions, drop me a message, send me an email, and I'll have a chat about what your potential claim is.